mode.
Hi, everybody. Thank you so much for being here. Welcome, welcome. We are going to begin. Apologies, we're a minute or two over, but it is thrilling to be here, and thanks so much. I am Katrina Bucell from HR Marketer, and our webinar today is 992 heads are better than one, balancing applicant rights and what employers need to know. A quick bit of housekeeping before we begin. We are going to have about 15 minutes at the end for Q&A, so please, we want to hear from you. Write your questions in. We will attempt to answer them at the end. If we miss you during the live part of this, we will be sure to get back to you and answer your question. Use the console, please, to ask questions. The lines will be on mute for the duration of the webinar. And we will be making a recording of this available to you within 24 to 48 hours after the session. So please know that that is coming, and thank you again. So for those of you who are not familiar with EmployeeScreenIQ, EmployeeScreenIQ helps employers make smart hiring decisions through a comprehensive suite of employment background screening services. These include the industry's most thorough and accurate criminal background checks, resume verification service, and substance abuse screening. EmployeeScreenIQ is accredited by the National Association of Professional Background Screeners, otherwise known as NAPBS, a distinction earned by less than 2% of all employment screening companies. I'm pleased to say we have 3 of the finest minds in the world of employment background screening. So without further ado, we have Jason Morris, who is President and Chief Operating Officer with us today, Nick Fishman, Chief Marketing Officer and Executive Vice President, and Angela Bosworth, Vice President of Compliance and General Counsel. I know you're going to find the session lively and informative, so Nick, I'll pass it to you.
Thank you very much, and thank you for joining us today. Let's just jump right into our webinar. We appreciate you being on here. Jumping in with the whole idea behind our survey, we all know that over the last couple of years, certainly if you've been attending our webinars or paying attention to our blogs, our industry and HR in general has been exposed to unprecedented litigation and legislation in regards to employment background checks. But in the past year, in addition to the litigation and the legislation, there's also been a lot of media stories putting both employers' use of background checks and consumer reporting agencies under the microscope in terms of how they are conducting background checks. Are they accurate? Are they fair? And so our mindset going into the survey this year was to really gauge, A, how people are using background checks, B, how they're making decisions, and C, how they are allowing their applicants to get the information and to be transparent with the process. So that being said, let's jump into our survey results. And the whole idea behind today's webinar is not only to provide you with the findings and the statistics. Those are important. But just as importantly is how those statistics apply to you as employers and how you can use them to create a better screening process at your organization. So we also want to share, at the same time that we're sharing our statistics, our experience with each one of these topics. And then lastly, because we want to make this very valuable for you, is also to share some compliance tips, and Angela and Jason are going to be pointing those out throughout each one of the topics that we discuss. So let's jump in, and we're going to talk about who our survey was made up of in terms of demographics. So this year we had over 992 HR professionals that are participated in the survey. That's a 51% increase from last year. And these represented a diversity of employers from industries, and those, important to point out, are not only clients of ours, but those throughout the marketplace. So we wanted to get a diverse mix of people. Key findings that we had from the webinar that we're going to get into today are the screening environment since the Equal Employment Opportunity Commission introduced their new guidelines almost a year ago now. It's been since last April. So we want to kind of not go over exactly what that guidance was. We think many of you probably already know that, but we really want you to know how employers have reacted to that. We also want to talk about the fact that our survey respondents are telling us that criminal convictions are not necessarily deal breakers. We're then going to talk about Ban the Box, and that is the job application question that asks candidates if they've been convicted of a crime. And lastly, we're going to jump into employers' use of social media. In particular, an interesting trend that we found that the number of employers using social media to conduct background checks on employers seems to be decreasing. So let's start with our first topic, and I'm going to turn it over to Angela for that. We're going to talk about the EEOC guidelines.
Okay, thanks, Nick. I just wanted to kind of introduce the topic a little bit. This year we had the opportunity to ask our survey respondents about the new guidance that came out last year about the use of criminal records in the background screening process and how it relates to discrimination in the workplace. We asked a question on our survey about how our participants were responding to the new EEOC guidelines, which came out in April of 2012. And the results were interesting. 32% of the respondents said that they had reviewed their screening policies and made some changes based on the new EEOC guidelines. 36% said that they had reviewed their screening policies and made no changes. And then 22% said that they were not familiar with the new guidance at all. And then 10% of the respondents said that they were aware of the guidance, but they just haven't had a chance to review it. So what does that mean? I guess we want to just take a quick step back and talk about the EEOC guidance and why it is important in the background screening process. The EEOC took the opportunity to review the guidelines, which have been in place for, since the 80s. They have been commenting on the use of criminal records in the employment process. And the reason that they took the opportunity to review the guidelines was there were some concerns about legal challenges as to whether or not the guidelines needed some type of updating. What we can take from this is, first of all, if you're in that 22% that has not had a chance to look at the guidelines or isn't aware of the guidelines, we strongly recommend that you take a look at the guidelines. If you need a copy of the EEOC guidance, I'm happy to email a copy to you. We have a white paper on the topic. But what employers need to look for is really whether or not the criminal information that you get from a background check is relevant to the job. So even though the EEOC guidance has been updated, there's still a focus on the same essential elements of looking at whether or not a person is the nature of the job, the nature and the gravity of the offense, or the time that has passed since the offense occurred. And then the new element that we're looking at with the new guidance is conducting an individualized assessment. So once you have looked at whether or not a criminal history is relevant to the job being sought, the EEOC guidance is now suggesting that you add an additional element of evaluation where you review the facts or the circumstances surrounding a particular crime and conduct an individualized assessment before making a final determination.
And Angela, also, if I could jump in and just pose this back to you, more reaction than anything, is we seem to be hearing a lot of employers saying, yes, we see the guidance, yes, we know what it is, but it's a little unclear as to what we're supposed to be doing. So I think that this information certainly helps. Can you share any experience you've had in speaking with clients over the course of the last year on it?
Well, when the guidance came out initially, there was a lot of confusion as to some of the recommended best practices and the idea that an individualized assessment would be an additional layer of review that employers have to conduct. There's also confusion over whether or not, if there is a state law that requires a criminal background check and restricts someone from hiring, say, a convicted felon, whether the employer can follow the state guideline or if, in fact, they have to follow the EEOC guidance and conduct some additional assessment and evaluate it differently. So, I guess those are the main areas of confusion, and I will say that there is still a lot of confusion about the guidance. The state law is not necessarily going to give you a safe harbor from an EEOC investigation or a Title VII claim. However, if there is a federal law that requires the criminal background check, then the guidance is pretty clear that would be protection for the employer. But as far as the actual individualized assessment, I think that's one of the main areas of confusion where we're seeing employers struggle to come up with a process to handle that particular part of the guidance.
Right, and I think that where they struggle is, well, are we supposed to do this in writing? Is this supposed to be done over the phone? Do we need to have an interview? And there really hasn't been guidance in that regard, but I think people are kind of adopting their own policies for it.
Yeah, Nick, if I can elaborate on that a little bit, I mean, in speaking with HR professionals, all over the country, they just don't get it. The larger companies, with sophisticated human resource departments and legal teams and everything else, they're starting to get their arms around this. But the smaller employers, that we see in some of these SHRM conferences and everything else that we visit, they don't even know about it. And when the ones that do know about it aren't sophisticated enough to really do anything about it, so they're looking for a lot of guidance when it comes to those specific things they need to do.
Yeah, so I think maybe for what will be emerging over the coming year is just hopefully more direction as to exactly what the process needs to be, and maybe that will be spelled out a little bit more in the coming year. Okay, let's move over to our next topic of discussion, which is criminal convictions. So we wanted to know among those people that were taking the survey, what percentage of their candidates that they hire have criminal convictions reported on their background check. And this speaks to, really, are you finding all of the records that you could? Well, this year, if you look at the biggest slice of the pie, you see that 59% of those that responded to our survey indicated that anywhere between 0 and 5% of their job candidates have criminal convictions on their record. Now, that's up from 49% last year. I find this information interesting because it's almost the antithesis of what we experienced at EmployeeScreenIQ. In fact, our criminal hit rates continue to go up. I also found interesting, it's only about 9% are finding criminal records on more than 16% of their job candidates. So I think that that's a very interesting trend among employers. And Jason, I'm going to, actually, before I turn it over to you, I'm also going to go to our next slide here. And this is very important. This is what we wanted to talk about in the last few years, and we finally figured out the best way to ask the question. So this graph represents, of the candidates, of the people that we surveyed that had criminal records, what percentage of those people were being denied employment? And so 71% of those that responded to our survey this year indicated that of the people that have criminal convictions, 0 to 5% of those folks actually don't get hired. And I think that that's a very important statistic to think about because it goes a long way towards saying that people with criminal records are not automatically disqualified as a result of having a criminal conviction. This was important to the EEOC. I know that in the general media, again, it's being reported widely that people are being turned away from jobs for the mere presence of a criminal record, and this data seems to suggest otherwise. Now, you can also look at, for instance, at the 3% of folks that indicated that greater than 20% of their applicants aren't hired based on criminal records. Well, you know, before we get too crazy about making comments or drawing conclusions from that number, it's important to point out that some folks are in regulated industries where they simply can't hire those with criminal records by their regulations. So, Jason, I'm going to turn it over to you for sharing some of the experience that we have with criminal records.
Thank you, Nick. Can you go to the next slide?
I'm there, is it not?
It just recycled. There you go. So, you know, this is one of the things that I like to talk about a lot, especially when we're doing, you know, or presentations or talking amongst ourselves, and just how effective background screening is and can be when you're setting up a program. When we take all of our statistics on a yearly basis, and I just lost my screen. Hold on one second. Excuse me. Nick, you can go ahead and cover
Okay.
this.
Well, okay. So in our experience, what we're finding is, in terms of where the records are being found, this chart shows you by by county where we're finding them. So if you were to only do a background check in your candidate's current county of residence, according to our experience, you're going to find about 43% of the records, which means if you're just doing current county, you're going to be missing out a lot. So if we add in the second county, you can see we're finding another 21% of the records. So obviously, the further back in your candidate's history that you go, the more criminal records that you're going to find. If I can switch over to our next, then we wanted to talk about not only what counties were you searching, but we also wanted to talk about how far back in time are you going when you're considering your candidate's potential criminal history. Again, this goes to the question of how well-rounded is your background check. Well, 46% of respondents say that they go back, as far further than 7 years, that's a good number. But 54% are taking a lesser snapshot of a candidate's potential criminal history. You can see that 32% go 6 to 7 years, but you've got a slice of folks there, 8%, that only consider 3 years or less. I'm going to just page down really quickly to share what our experience with that is. Jason, are your slides back up?
Yeah, but I'll apologize if I have to keep going in and out here. But I want to highlight some of the importance of when you're setting up a program and how important these statistics are when you're setting up that program, because a lot of times HR professionals, they set things up because they were told to do things a certain way or set the program up in a certain way without looking at what the impact of that program can be. And when you look at the actual statistics and relate it to your own hiring, you could really be missing a lot of records. When you look at, and I know, Nick, you covered a lot of this, but when you're looking at how many people you hire on, let's say, a yearly basis, well, 26 to 30% that we're finding, that's 30 out of 100 people. So if 100 criminals are applying for a job with you, that's a lot of people that I can get through without doing the background check properly. And those are game changers. Those are career changers for HR professionals if these things aren't done properly.
Yeah, and again, just going back into our experience, if we relate it to the last graph, we're finding 67% of all records within the past 7 years. But you can see that leaves still a huge chunk of criminal activity that we're finding well beyond those 7 years. And so, again, for the most well-rounded program, of course, where state law does not dictate that you can't go back beyond 7 years, you certainly want to get as much information as you possibly can. And Angela, I'm going to turn it over to you for some helpful advice that employers can use when setting up their criminal background check program.
Right, and I just want to go back to something that we just talked about with the criminal records. You could be missing critical information if you're not going to the full extent of what's available. But employers also have to keep in mind those EEOC factors of job relatedness and relationship to the job that's sought or held, and the amount of time that has passed since there's been a criminal conviction. So taking into account using all the information that you have at your disposal, which is really, really critical, but also making sure that your policy takes into consideration how that relates to your particular position. And I would recommend make sure that you're looking at your policies, that you are including in your policies information about how you do weigh those different factors. Make sure that you understand with your provider what the sources that they are using consist of. How is your provider reporting that information? What steps does your provider take to make sure that the information that they are reporting to you is accurate? Your provider should have policies, and they should be able to demonstrate to you exactly where the information is coming from, how far back they are looking, and what steps they're taking to make sure that the information that they're providing is accurate. And then you can audit your provider. This is something that our clients hold us to the our feet to the fire all the time, and we know when we're being evaluated that it's our responsibility to make sure that the information that we're reporting is accurate and up to date. So it's okay to ask those questions and find out what the sources are, how far back they're going, and what are you actually getting for your money, and is it the kind of program that your organization needs.
Okay. Jason, any other thoughts on this?
No, sorry. Having technical difficulty still.
Okay, sorry about that. Okay, so we're going to go ahead and move into our next topic of conversation, and that deals with the whole ban the box movement, that we've seen a lot out there, particularly as it relates to the job application of whether your applicant has been convicted of a crime. Angela can certainly talk about this. This was also in the EEOC guidance where they recommended that employers consider removing this question from their job application. And I believe, Angela, correct me if I'm wrong, the advice was if you don't, you might want to make it more specific to the type of job that they're applying for. Is that correct?
Well, I think what the EEOC sort of hinted at in their guidance, and in fact made a recommendation, was that employers consider deferring any kind of question about criminal history until later in the hiring process. And the common practice in the past, and many of our clients and many employers still have the practice of asking the question on the job application. And there is a concern that has come out in this ban the box movement that by asking the question on the actual application that you are eliminating potential good candidates way too early in the process. And so what the EEOC suggested as a best practice in the guidance was to defer that question until later in the process. What is still very unclear and I think confusing for employers is there's no clear guideline on when is the right time to ask the question. So at what point in the process is it appropriate and legal to ask about a past criminal conviction? And I think that our results, if you want to go ahead and advance.
Yeah, so what I found very interesting here when we talk about the results, couple things. This first slide is going to show you, we asked people, do they ask their candidates to self-disclose on their job applications? 79% of employers that responded are still asking that question, and that's fine. What I took note of, though, particularly, are the folks that don't ever ask the question. And so we've got this slice of 3% that, I'm sorry, slice of 9% that say that they don't ask about prior criminal history. And then we've got this no other 14%, that are basically saying, no, we don't ask. We found that to be interesting as well. What I really found interesting was the next finding, and we were intrigued by this. We wanted to know, would employers be more open and receptive to candidates if they were to disclose, self-disclose information on the job application? 52% said that they were more open to hiring those that had criminal records if they were to disclose it on the application. 7% said that they would be less open to hiring, and 40% said it would make no difference. Now, that 40% number is interesting because it would be good in the following years to kind of ask, okay, well, does that mean it would make no difference because you wouldn't hire them or because you would? But we really found that this information was eye-opening. Angela, do you want to comment?
Yeah, I think, you know, when I've talked to employers and when they've asked about this particular issue as a legal question, oftentimes they're asking the question on the application to check to see if an applicant is honest. So, you know, if they disclose a criminal conviction and this was really a test to find out, is this person going to be honest and disclose, and then they take that information and they weigh it against, you know, if they take the nature of the offense and let's say it was, you know, a misdemeanor or even a non-violent felony, and they weigh that information and decide that this person is still a good candidate, then they can advance them through the process. But it is interesting, the high percentage of respondents who seem to be very open to hiring an individual even if they find a conviction upon disclosure.
Yeah, and again, going back to the advice that you said is if you still do remove this from the job application, you just really want to make sure that you're asking it at another point in time, because you know this doesn't stop you. Ban the box doesn't stop you from ever asking the question. It just stops you from asking on that job application.
One thing I think is also important, sorry to interrupt, is whose responsibility that is. And again, in talking to employers, they say, some of them have said, you know, that's part of my application process, that's in my applicant tracking system, and that, you know, the applicant tracking system is responsible for that. Well, they don't realize that the applicant tracking system is nothing but software, and it's their responsibility to contact the ATS and let them know of the changes they want made. Don't assume that just because you're paying for software that those changes are automatically going to get made without you consenting to it or asking for it.
And one final thing on Ban the Box, I would just strongly encourage employers, particularly those who are hiring in multiple states and multiple jurisdictions, make sure that you know the law of the local jurisdiction where you are hiring, because there are so many new state and local laws that are popping up all around the country that there is no one consistent national standard. And even though the EEOC guidance speaks to this particular issue, they don't give any clear direction on what, you know, at what point in the process is the best time to ask the question. And then the other thing to keep in mind is the EEOC guidance is just that. It is guidance. And we know that many employers will be able to successfully defend asking the question about a criminal history just based on the nature of the job and by having a good process that takes into account the individualized assessment.
So, Angela, if you're in an industry that's regulated in which you can't hire those with convictions, how are you supposed to respond to these laws that are asking you to remove it from the job application?
Well, if you are in a jurisdiction where you can't ask the question on the job application, you are going to have to defer the question until later in the process. And when that would be appropriate would depend on the particular law or regulation in your jurisdiction, and they're all different. So unfortunately, I don't have a boilerplate or cookie cutter answer.
No, I knew you wouldn't. I think that's the important point in this whole thing.
Make sure that you're consulting with your legal counsel. If there is a state or local law, and usually there are state laws that prohibit hiring a felon, you know, you're going to have to review your process and make sure that you're not putting your company at risk for investigation or a claim for discrimination, yet at the same time, you're going to have to make sure that that you're maintaining a safe workplace and not risking a bad hire or theft or injury or crime in the workplace. So,
got it.
Employers are on the hot seat.
All right. Let's move into our next topic. That is social media. This is a question we've been asking in our survey for, I think it's been about 4 years now. And we noticed an interesting trend this year. So when we asked how many employers were using social media to conduct as part of their background check, 7% indicated that they are always doing a social media background check before they hire somebody. Now that's down from 9% last year. Okay, 64% are never using it in their process, and we'll get to those folks in a minute here. And then we have 29% that use it sometimes. Now the 29% is down from 39% last year. So it's interesting that the number seems to be declining, and we've got a couple thoughts on why that might be. But before we jump into those thoughts, we asked a follow-up question to those that say that they don't use it, because we're curious to know, why don't you use it? And not that we were saying you should, but we wanted to know why they didn't think it was important. So you can see that 69% said that they were just concerned about privacy laws and legal risks. 31% just didn't think it was relevant to the job at all. And 32% just said, hey, you know what, we don't have time to do it. Jason, do you want to share some information on social media, what we've seen over the last year or so?
Yeah, I mean, I would hope that the reason that some of these numbers are declining is simply because people are listening to us. We've been very vocal about social media for the last 5 years, and whereas I know everybody in the world doesn't read our blog and read our information, some do, and I think the word is spreading that it's dangerous to do. And we've seen in the papers and on the news how it can go back to even bite a company when they try to dig into somebody's social media past. I think first and foremost, companies are realizing that it's bad for the candidate experience. Who wants to work for a company that is going to dig so far into their background they're going to look at personal pictures and personal history of things that they've done on their Facebook? I think that companies are now realizing that that's just not a place that everybody wants to work, and they're really trying to concentrate on forging a good candidate experience. I think the other reasons you're seeing it declining are because of accuracy. You just don't know what you find on the internet is accurate. Look at Monte Teo, all the things that happened with him. And he's the defensive guy from Notre Dame who was. There's a story out there about him having a girlfriend. She wasn't really a real person, and it was public that she died, and she wasn't even alive. So it really blew up into the media's face because they didn't fact-check any of their information before they started reporting on it, and the media got a lot of heat for it. But we've seen other litigation and other cases over the years where companies even attempting to do this it's just really coming back and blowing up in their faces. There was a university that hired a man. They had a committee that did a search for a professor and found out that that professor had after they decided to hire him, found out that he had a web page out there about creationism, and he decided to rescind the offer based on his religious thoughts. Well, he found that out and sued. There was a long paper trail of emails going back and forth amongst the committee, and the university had to go ahead and pay a settlement to him. All things that could have been avoided had they not done these types of searches. What we've also seen is employers saying, well, something I'm going to use for recruiting, I'm not going to use it for background screening. Well, there's other liabilities there as well. Simply using somebody's LinkedIn, or simply using LinkedIn to hire for one position could put you at risk with discrimination claims. If you look at the population of the United States, it's something like 14.5% Latino and 12-point-something% Black. Well, the LinkedIn population is 5% and 2% respectively. So if you're just using a site like that to do recruiting, then you could be discriminating against minorities. So that's something to keep in mind, especially if you have to be OFCCP or Order 11246 compliant as a government contractor.
So I want to take the information that you shared and turn it around a little bit, Angela, as I turn it over to you. Because we do know there are still employers that are using it, and whether they use it all the time or some of the time, and wanted to see if you had advice for those folks that are using it, and maybe even talk about why you think they might be using it as well.
Well, sure. I think it's. I think a lot of employers might still run to Google or Facebook to find something out about a candidate, just because it's what we do. It's our nature. It's easy. It's free, and with the billions of people that are on Facebook, it's become ingrained as part of our culture, and it's natural to want to know and find out. And so I think people want to know if a person's going to be a good cultural fit. I think it's a natural inclination to kind of want to see what kind of networks people are involved in, and again, depending on the job, are they going to fit in with our company? And so as part of a background check, I think it's natural that there's going to be a curiosity, and some very useful information can be gained. What you need to be careful about, though, is some of the things that you might find through a social media search, as Jason mentioned, might be things that are illegal to consider in the hiring process. So if you're finding out information about a candidate that you wouldn't otherwise find through a legal screening process or a background check, things that have to do with protected class information, someone's race, someone's religious persuasion, someone's sexual orientation, or even a handicap or a disability that could easily be revealed through Facebook or a LinkedIn group, for example, or someone's blog. Once you see that information, it's almost impossible to legally separate your hiring decision from that information if you're challenged. So be careful what you might find, and if you do decide to, pursue some type of a social media search, make sure that you're being transparent with the job applicant. You might consider obtaining a release, and don't ask for if you ask for a password, you may be violating the law, and you may be crossing over into a violation of privacy, which could cause some additional legal issues. And if you do have staff that are looking at social media sites to help screen applicants, make sure that they are very well versed in Title VII and discrimination laws, and make sure that those individuals are not the same individuals who are making the hiring decision. In other words, separate out that screening process so that there is an opportunity for someone who is educated and well-versed in the pertinent laws to actually vet that information and take out any information that might be illegal to consider on behalf of the hiring manager.
I think I have a couple more tips if you don't mind.
Yeah.
The important part about creating a policy is not just so your employees have to follow the policy, but it's so let's say it's something that you don't do, you don't consider social media information or even search for social media information. It's important to have a policy, written policy, that says you don't, and that a policy that you're training your staff on a regular basis, because the only defense you might have against the claim that somebody says you didn't hire me because you saw it was pregnant on my Facebook site is the fact that you have a policy that says you don't do that. So I think that's another good thing for professionals to consider. The other thing is to make sure that if social media is something that you don't consider, let your candidates know it's something you're not even going to look at. If they know ahead of time you're not going to look for it or search for it, then they have nothing to worry about. And it tells them also, if you do make a decision not to hire them, that probably wasn't the reason that you didn't hire them.
Okay. So those are the topics that we had prepared for today, and just wanted to let everybody know that we would be releasing the actual survey report. I believe it's going to be released within the next week to 10 days. So to be on the lookout for that, we've got some great information in there. A couple other key finding areas relate to resume distortion or lies. This information that we found is very consistent with what we found on criminal records, that even though employers find that applicants are, in fact, distorting information about their past experience or education, that only a small percentage of them are getting denied employment based on that. So we found that was a very interesting finding, and you can read more about that in our survey report. The other finding 2 years in a row now is that 71%, literally the exact same number, that indicated that NAPBS accreditation was important to them, indicated for a second year in a row that that is in fact important for a background screening firm to have. Now, the reason we find that interesting is because less than 2% of all screening companies are NAPBS accredited. And you know, it's important for employers to know that just because somebody is a member of that organization does not mean that they're actually accredited. So
I think it's also important to highlight, Nick, what accreditation is. You know, it's something that an employer has, that a background screening firm has to score 100% on. It's not something you just get, you know, good enough with a 70%. There's over 70 standards that a background screening firm has to demonstrate to an independent auditor that they're doing. So, for example, truth in advertising. If you're saying you're doing something publicly, are you really doing it? There's an auditor that's going to come in and make sure that you're doing it the way that you're claiming to do it. And there's other provisions in it about security and data protection and stuff like that.
Okay. All right. So again, to go over the key findings, again, we talked about the EEOC changes. We talked about criminal record convictions and about the Ban the Box movement, as well as social media screening. And now that we've talked about our key findings, I imagine that there might be some questions out there among the folks that were participating in the webinar. And Katrina, I'll leave it to you to pass those questions
Fabulous.
along.
We have some great questions, and I'd like to start with one that you all probably get quite a lot, but it is absolutely on the minds of a number of people here, and they want to know, and I'm combining three questions, what is the best practice for timing on when to conduct a background check? Pre or post-offer? In your experience, is there a best practice on this?
I think it really depends on your workflow and what's best for your company. We've got clients that do it all. We've got clients that do a background screen on every single applicant that applies for the job, which can be very costly, but it fits in well with their workflow. To clients that do it, you know, right before they're going to make an offer. To clients that make the offer contingent upon the completion and passing of that background check. So I wouldn't really say that there's a best practice for it. Angela, you might disagree, but because we see it all. Angela, do you think there's any standard out there?
Well, I think it's really job specific, and it's hard to generalize with any one golden rule. I would say one thing that we know is frowned upon is to have any sort of a bright line test or to have a policy that says we're not going to hire anyone with any criminal conviction. Any type of a bright line test like that will be suspect by the EEOC and state agencies that enforce discrimination in the workplace. So beyond that, you're right. We see it at many different points in the process, and it really depends on the particular job and the economics of what makes sense for the employer.
Yeah, we even see, and we've been seeing this trending up over the last couple of years, companies are continuing to screen people once they are already employed, maybe on an annual basis or a quarterly basis, because, look, people can get arrested and convicted while they're employed just as they can while they're not employed or looking for a job. So the risk is there, during employment as it is pre-employment.
What do we got,
okay,
Katrina?
I'm going to try, if we have time, to ask questions in the different categories that you did, because there was, significant interest in all of them. This one has to do with the social media conversation and the hiring of a third party. Again, I'm combining two questions. One is really, is it a best practice? What do you all think about hiring a third party to conduct a social media search in particular for a candidate, for a potential candidate, and then combined with that, someone is wondering, what if it's kind of a modification of that? What if you tell that person, look, we don't want to hear anything from you unless it's, it has to do with egregious, acts, and I'm sure they define that in some way. So it's kind of a two-part question. Hiring third party, or maybe that's it, hiring third party for social media screening.
Yeah, well, certainly as far as hiring a third party, it's very important to understand that the Federal Trade Commission is going to look at any third party that does this on your behalf as a consumer reporting agency. That means that your applicants need to provide authorization and consent in written form, allowing you to conduct the social media background check. That also means that you have to give applicants the opportunity to be able to dispute the information that's found. And you also, of course, have an obligation for maximum possible accuracy. Angela, I'll let you join in as far as how you deal with maximum possible accuracy with with social media. Jason, I throw it out to you as well.
Yeah, the issue with social media is that most of the content is self-generated, and whenever you have content that the user is generating themselves, there's no way to really verify the accuracy. We all know that you can also post photos that have been photoshopped, and everything you read on Facebook is not necessarily true. So we know that there are inherent problems with the accuracy of the information, and it's almost impossible for a third party to be able to verify the accuracy of everything that they might find in a social media search. That doesn't mean that there aren't certain elements that can be identified and flagged and reported responsibly. Our experience has been that we just haven't found a lot of viable ways to do that as a third party. And Nick makes a good point. Once you do source this out to a third party, all of the requirements of the Fair Credit Reporting Act kick in, and all of the disclosures and notices and the accuracy provisions are required. And the FTC has gone so far as to say that even some of these websites like Spokio, once they are used for employment screening purposes, that they become a consumer reporting agency, and they are subject to all of the same laws that any other background screening provider would be subject to.
Right, and it's important, I think, to point out, too, whether that they say they are a CRA or not, even by saying that this is not an FCRA product, that doesn't make it so.
Mm-hmm.
If they know it's being used for employment.
Right.
Any other questions, Katrina?
There are. I'd like, under the category of criminal records, there were a number of questions. I think, though, kind of a best practice question that a number of people seem to have is, how far back can you legally go in terms of people's criminal records, and then what do you suggest in terms of a best practice?
Angela, do you want to take that?
Yeah, I'll take that. There are a couple of different legal considerations for how far back you can go on a record. Consumer reporting agencies like EmployeeScreenIQ and like other background screening companies, we have to follow the Fair Credit Reporting Act on what is legal for us to report. So there are limitations for us as providers, and the Fair Credit Reporting Act says that we can go back and we can report things as far back in time as they are available, as long as there is a clear conviction. And there are state laws that give us some additional requirements that say you can only, for example, in California, we can only report 7 years in the state of California, regardless of whether or not the information or the record is a conviction. So some of it is going to depend on which jurisdiction we're reporting in and where the candidate is located. And then there are other factors to take into account. Unfortunately, this isn't a quick answer, but employers also have to take into account the EEOC guidance, which is to look at the amount of time that has passed since an individual was convicted. And so the EEOC is saying, you know, it may be legal for you to look at all of these records, and it might be legal for your background screening company to report this information, but you need to take into account as an employer and your policies the relatedness or the job relatedness of that particular offense to that particular individual.
Yeah, and one other thing that I want to jump in on as it relates to criminal history, we had a slide loaded up, and I'm not sure why, for some reason it didn't end up in the presentation, but we had some technical difficulties where among the survey we were able to analyze what types of criminal records are employers concerned about. And in the past we've just said, well, are you concerned about felonies? Are you concerned about misdemeanors? This year we asked, well, what types of felonies concern you, and what types of misdemeanors concern you? I don't think anybody's going to be surprised to know that, of course, employers are more concerned about felonies than they are misdemeanors. But the type that they're most concerned about is, of course, violent crimes. And that, by the way, not only were they concerned about violent crimes of the felony sort, but also of misdemeanor sort. The next biggest concern for them were crimes, whether they be felonies or misdemeanors, that involve theft or dishonesty. Interestingly, those that were people were least concerned about were felonies and misdemeanors dealing with any kind of drug-related charge. Now, also another follow-up on what Angela was talking about is in terms of age and even in terms of severity of record, is that what I'd love to be able to do in the next survey is not make that answer so flat, because it's not necessarily the one misdemeanor that might make employers leery, but it could be a history of them. So going into the timing question, you know, maybe it was a misdemeanor that occurred 20 years ago. But if, you know, the same misdemeanor, or there's been repeat charges that are misdemeanor over a period of time, then that certainly, my guess is, would draw concern from an employer. So
I think the reason that information is so interesting and just really interesting is because when you look at some of the reasons the EEOC came out with their guidance was because they're afraid that, you know, HR professionals are just, you know, not letting people get jobs because of anything. And I think what people seem to forget is recruiters and HR professionals, they're trying to find people to work for them. They're trying to include people into their organization, not dissuade people from working there, not trying to push people out because of anything. Their job is to find good people, and that's what they're trying to do. They're not just taking any conviction and not letting somebody work there because of that.
Have we got any more, Katrina?
Yeah, we have. This might be an easy one, and it relates to the question about criminal convictions and the amount of time. We haven't talked at all about civil issues like bankruptcies and other civil issues, judgments. And the question is, what's up with civil as it relates to criminal? Is it different?
Jason, you want to answer that?
Apply to that?
Yeah, I mean it's completely different. I mean there's a lot of things on the civil record that you should never be touching when it comes to employment. That could be, you know, domestic information, divorces. There's different bankruptcy laws when it comes to bankruptcies and different financial things you have to follow. And there's even some laws against not hiring people because of actions taken against employers or workers' comp actions against employers. So I would be very wary of using only that information to make a hiring decision. But I would definitely consult with legal counsel as far as what you should be using or can use if you're to do that.
Proceed with caution. I think we'll end there. And please, they were fabulous questions, and please know that EmployeeScreenIQ will absolutely get back to you and make sure that your question is answered. So thank you for writing them in, and they're great questions. Nick, do you want to go ahead and take us to the finish here, wrap it up?
Yeah, so again, I just wanted to thank everybody for joining us. As I had mentioned before, we will be distributing the actual survey results within the next 7 to 10 days. In addition to that, anybody that has been participated in today's webinar, we'll be sending you a recording in case you want to review again. For those of you that do, I imagine you're pretty much masochists at this point, but I hope that you enjoy that and feel free to share with your colleagues. And I think that's all. Thank you very much for joining us today, and take care.